It's been 12 months since your mom died. You and your sister are your mom's only children. She established a trust a few years ago. She made herself the trustee during her lifetime, and her accountant, Mumford Pennypincher, the successor trustee. Your mom's real estate, securities, and bank accounts are assets that are in the trust. The trust provides for the support of your mom during her lifetime. The trust does not become irrevocable until she passes away. Since the trust is revocable during her lifetime, your mom can invade all, part, or none of the principal and income for her benefit while she is alive. A few weeks after your mom passes away, you ask your own estate planning attorney, Maggie Einstein, to review the trust and to explain it to you. Maggie calls it a support trust. She explains that it has terms that provide that the trustee has discretion to distribute either income or principal among you and your sister, but only for your health, education, maintenance, and support. Maggie also explains that the Association of Irish Wolfhounds, the Wolfhounds, is the remainder beneficiary of your mother's trust. She says that though the Wolfhounds, the remainder beneficiary, may at your deaths be entitled to the entire remaining principal, until then, they're entitled to nothing. Mumford Pennypincher, now acting as a trustee of the trust, is really difficult to communicate with. And you feel that you're getting the runaround. What little information that you have received is Mumford's express concern that he must administer the trust to preserve capital. Your lawyer, Maggie, says that while this might be so in part, Mumford has a primary duty to deal with each of the beneficiaries impartially. And this includes successive beneficiaries like you and your sister and the Wolfhounds. Mumford seems baffled. He doesn't know whether to invest for a maximum current return, a reliable income stream, or toward a goal of increasing the real value of the principal over time. He's really frozen. His current stance is to provide you and your sister very little income and very little information. He makes no inquiry as to your current needs for your health, education, maintenance, and support. In addition, you learn from the president of the Wolfhounds that Mumford has not communicated with them at all. The case is not going to the dogs. It's going nowhere at all. So you're in a predicament. Do you let Mumford proceed along on an uninformed, secretive, and unfair path? Or do you do something? And if so, what can you do? Your estate planning lawyer, Maggie, tells you that she knows that you do have some remedies. That said, she says that she is not a litigator and that you should talk with lawyers experienced in estate and trust litigation. You call us. So I'm just going to hit a few high points. You have the right to an accounting from Mumford Pennypincher. Mumford doesn't have the unfettered right to keep you in the dark. Mumford has investment responsibilities that he may now be failing. Mumford does not have absolute discretion to deny you resources that are needed for your health, education, maintenance, and support. Mumford is subject to what is called ascertainable discretion. Doing nothing is not within the bounds of ascertainable discretion. Any probate court action against Mumford would generally be located in the county in which the trust is being administered. Sitting on your rights is not the best plan. You can contact a lawyer experienced in trust and estate litigation, and you can explore your options with regard to attorney's fees and cost. At our firm, Hackard Law, we take substantial cases where we think that we can make a significant difference, and there is a wrongdoer who can be made financially accountable for their wrongdoing. We are California-based, and we litigate only in California superior courts, both civil and probate. We focus on California's largest urban courts, including those in Los Angeles, Orange, Santa Clara, San Mateo, Alameda, Contra Costa, and Sacramento counties. If you'd like to speak with us about your case, then call us at Hackard Law, 916-313-3030. Thank you.